Good morning, council. Welcome. Our second argument today is Webb Roofing and Construction LLC versus Edison Insurance Company, case number 24-1028. As I said before, it's 20 minutes per side. Counsel for appellant, typically we reserve 5 minutes, but we can change that if you prefer. Okay. Well, whenever you're ready, counsel.
Thank you. May it please the court. My name is Mike Fink from beautiful downtown Fort Myers, Florida. I represent Webb Roofing and Construction LLC. Primarily, at this point, one of the owners, 50% owners, Brian Webb, and the other owner is Brandon Jordan. I want to make a couple of points right up front, and then clarify some of the issues related to quantum error that may be confusing, by the way, maybe. Number one, this is the quintessential voluntary withdrawal by an attorney representing a plaintiff waiving their fee under the Farrow case. Quintessential. Number two, there is no agreement of any kind in writing, never has been, between Webb Roofing Construction LLC and Fromain and Finch PA. There's no email saying we're going to apply the prior firm contract. There's no communication at all. There is nothing. Having said that, the analysis of the case should begin at the issue of whether or not the attorneys, the charging lien attorneys have, and whether the evidence below satisfies and is sufficient to determine and find that the charging lien attorneys involuntarily withdrew based on something that Mr. Webb did wrong. It's a corporation, it's a company they are representing, Webb Roofing and Construction LLC, not the personal individual owners. And in this particular case, it's simply, there's really not anything there because Mr. Finch never speaks with Mr. Webb after they were signed up and had a meeting. From that point forward, he never has a telephone conversation. They don't write emails to each other. He refuses to have any connection or communication with Mr. Webb because he's only listening to Brandon Jordan, who within a couple months after undertaking the representation, Mr. Jordan sets up a new company, competing company, Re-Roof Plus, competing with Webb Roofing LLC, Roofing and Construction LLC. That proceeds from 2019 all the way to March 2021, when the charging lien attorneys withdraw, and they claim that they have to withdraw because now they've got to communicate. They were required to communicate with Mr. Webb as well, and that because he was part of the management team and owner of 50% of the shares anyway, that meant that they, I believe what the evidence showed was that Mr. Finch had an issue with, he never wanted to talk to Mr. Webb, period, because of these other issues and issues of control and the issue of the litigation committee having found this $869,000.
So are we taking for granted the fact that Mr. Jordan was named a representative for Webb to talk to the firm, or no?
The only person that says that is Mr. Finch. It wouldn't matter as far as I'm concerned, representing, wait a minute, let me back up. I recognize that that's the position of the charging lien attorneys, but it doesn't impact whether or not you should be able to communicate with a 50% owner, or whether or not you should be sending settlement checks to different addresses called for by Mr. Jordan, and whether or not, and this is why my client eventually signs the affidavit saying, hey, you're funneling money to him. The only thing that my client separately, not Webb Roofing LLC, which is of course the client that they withdrew from, is he signed an affidavit saying, hey, you're funneling money over here, and the court went through and of course made them write the check, made Brandon Jordan write the check and transfer the $800,000. I mean, that was done, nothing unreasonable about that. And there's nothing in it that creates, that should be deemed a conflict, creating a conflict by standing up for your rights and saying, hey, this is happening. It was happening. And the second thing is the bar complaint saying, I want him to talk to me and communicate with me, which was essentially dismissed or whatever. And they said, they sent a letter to Mr. Finch. And so they sent a letter to Mr. Webb, carbon copy to Mr. Finch, and said, hey, it's a civil matter. So the bar didn't get involved, but later, of course, Judge Hayes in Naples said, hey, you've got to talk to Mr. Webb as well. He owns half the company. So that's when they withdrew in March of March of 2021. And that's before the receiver even gets put into place. I mean, the way the evidence was presented by Mr. Finch is not, we take issue with whether it was accurate or not, and what was placed in the order by Mr. Finch when he wrote the order of the trial court. It made it seem like the receiver was in and there was more to it. There really wasn't. They withdrew from all cases filed their motion to withdraw in March from all cases. You know, as far as we are concerned, without any communication with Mr. Webb, without anything except for a third party bar complaint that didn't arise to anything and that they didn't file a bar complaint right away or it didn't withdraw, he asked to be contacted. That doesn't seem to me to be anything that warrant or support an attorney withdrawing and getting paid on the quantum merit. And that's a good thing. I just brought that
If
up.
we were to disagree with you as to the voluntariness or involuntariness, I mean, for starters, it sounds to me like that's a different standard of review for us because the trial court made this finding, right? And indeed had to amend the order in order to determine that it was an involuntary withdrawal. Assuming we weren't going to touch that finding, and I'm not making that
That's
ruling
exactly
today,
where I'm going. That's exactly
to
what
quantum merit.
I'm
Okay, can you help me with quantum merit?
I think, and I'm not think the brief is great, but I want to make clear that that the law in Florida is that if a client hires an attorney, whether there's a fee agreement or not, if the client fires the attorney, they get quantum merit. If the fee agreement in this case is valid or invalid, because the case did not settle until after they withdrew, it's a quantum merit matter. So whether the fee agreement is valid or invalid, because the contingency did not occur during the representation, it necessarily leads to solely a claim for quantum merit if they did not voluntarily withdraw. So
You would agree then that they would be entitled to the quantum merit fees?
if they did not voluntarily withdraw, there would be some award of a quantum merit fee, whether or not the underlying fee agreement is valid or invalid, and even if they did not have one. In this case, they had a 10%, and that's how they marketed it. They said, we're going to take your cases, we're going to charge 10%, everybody else is charging more. This is the amount of, this is what the insurance, independent insurance folks were charging to take on a case. But anyway, Rosenberg says that whether the fee agreement is valid or not, the contingency in that fee agreement is the cap. So if they did not voluntarily withdraw, and whether or not the fee agreement is valid or invalid, they would be entitled to a quantum merit fee capped or limited by the contingency of 10%.
But you're saying to us that that agreement is invalid. Like if that,
I absolutely
if that agreement is invalid, if we don't look at that at all, then wouldn't we just be in a situation where we're looking sort of in a first instance thing without the help of any documentation at a quantum merit analysis? Then why would we also, like, is it bringing in something improper if we were to agree with you that the agreement was invalid under under Florida case law perhaps, and under the rules? Why do I still have that cap if the agreement's unenforceable?
Because of Rosenberg, because it would be public policy. You should not be able to provide the client, let's hypothetically, provide the client with a invalid fee agreement and then be able to make a fee higher than what that invalid fee agreement said that you had the client sign. It's a matter of, you can't benefit by making a mistake or providing an invalid fee agreement that doesn't comply with the 4-1.5. They clearly have, they cannot, and they don't have anything that complies with 4-1.5. Now, council may say, well, we took in the case. I filed the complaint under Finch Law Firm and personally in June 30th of 2019 against the wrong defendant. By August, Finch and Fromain is going along, and then all other cases are all brought completely under Finch and Fromain. They're all started in fact, Finch and Fromain filed an amended complaint in November of 2019, dropping the good faith covenant cause of action and the deck action, leaving only the breach of contract action against the wrong insurance company. And in fact, it's not corrected until August of 2021, after they have withdrawn and so forth, where the new firm comes in and says, hey, we need to put the right defendant. They sued Florida Peninsula Insurance, and it's Edison Insurance Company that should have been sued. My point is, even if he started it, that's a nullity as far as I'm concerned. But if he didn't think he was a nullity, he'd get a couple of bucks for filing the actual wrong complaint against the wrong defendant.
Well, it happens all the time, right? You see it Allstate Castle Key and so
Well,
Allstate Insurance Indemnity. I mean, it's fairly typical that happens in first party insurance cases. Is one umbrella insurance company has multiple.
it's not typical that you sue Florida Peninsula and months later, Edison Insurance Company comes in and answers, changing the pleading themselves, answers as Edison as a defendant in a case where they're not a defendant. That happened. And I'm not even going to get into that analysis, but I like David Loeb's office, who took over later on after Finch and Fromain in August, amended to include, make sure we have the right defendant. At that point, obviously it's pointed out to you. I'm just saying that.
Okay.
Maybe I'm getting, not necessarily, it's a little bit of a, I don't want to go on a rabbit hole. It's important, but the point being, everything is Finch and Fromain. There is no agreement. There's no case that allows you, and no case in Florida, and been doing this 3 years with another roofer. We've been before this court, before in the massive matter of the matters. There's no case that allows you to take a fee agreement to a new firm with new lawyers, period. There's no ratification cases. There are none. And the law and the rule changed. You've got to have
If there had been an email exchange here, would that have been okay? So I have a fee agreement between firm one and that client says, or the lawyer in firm one says, we're going to send these cases to firm two, who we have a relationship with. And the client says, okay.
I have a perfect answer. If the appellate court, meaning justices just like you, decide that constitutes a fee agreement in writing complying with 4-1.5, I would agree.
Is that what the trial court did here? Because he had all of these sort of acknowledgements back and forth between the emails and then found that these are it's constituting electronic signatures, and he makes a finding in that regard.
Certainly, obviously Mr. Finch wrote exactly what he wanted to write. I don't know specifically what the trial court thought other than what Mr. Finch wrote, but there is no case that allows you to ratify like that. And there is no email saying what.
Well, forget if there is no case. Analyzing it from first principle. Is that wrong?
They did follow through, and they didn't charge him. I'm not going to go into what they really charged, but at any rate, they recovered on many of these cases, signed all the releases as they were requested. That's true. That unfortunately doesn't, in my view, because it's so important that there be a understandable, clear fee agreement between clients and attorneys. And that's why I in this case, if it is invalid, then the purported prevailing fee provision, which in my opinion, wasn't litigated. There was no affirmative relief asked. It was my motion to strike that was actually heard. And somehow we ended up with an order that says you get this extra money, this enforcement fees, when it wasn't discussed. And it, as far as in my opinion, doesn't apply, because that provision in that invalid contract doesn't specifically say we're going to charge you, Mr. Client or Mrs. Client, with what the fees it takes us to obtain these previous fees owed. It doesn't clearly say that.
Council, can I
But-
get you back to the email issue?
Yeah.
So is it your contention? I hear you saying there's no Florida case that allows for this.
Right.
Is that one, different because this is a contingency fee, agreement? Like, does that matter? And then number two, which I wish I'd have started with, because this is the one that's most important to me. Are you saying that this debt, it could be an email that would suffice, but there is no such email that checks all those boxes under the rules regulating the Florida bar?
I'm saying, I brought that up because there isn't one, but if there was one, I would still say we have 4-1.5 and it is and it relates to contingent fee contracts must be in writing, and it is standard fee.
So it's just that no email satisfies that rule in your
Right.
mind in this particular case.
That's correct. And there's not one even presented to attempt to bridge that Grand Canyon of a gap. Period. So as I look at this case, one, it's a clear case of voluntary withdrawal. How can the client be responsible for the attorney deciding to withdraw because he doesn't like the client, doesn't want to deal with the client? Issues between clients and attorneys happen all the time. Somebody complains or says they don't like what you did. These things all are worked through. It's normal. They don't constitute the right on behalf of the attorney to claim that, it's a adversarial position. Well, it's his ed. He created the conflict in the first.
Didn't y'all agree it was a conflict, albeit after the fact?
I'm glad you brought that up, because I believe that what the lawyer meant 2 months later, after they already, and you're very, very astute to have caught that. What is there? I assume this, the only thing they can say is, was it a waiver? Did they say that they were agreeing with him? I think what he meant was you created all this by how you dealt with my client and vis-a-vis Brandon Jordan and giving all the money to him, sending it to different post office boxes and the checks and not communicating with Mr. Webb. That's what I believe he meant. And by that point, maybe they did, because he was clearly not going to ever talk to Mr. Webb, no matter what judge said it. And even I'm not sure that's in there. There's so many transcripts and so many deputies. I don't know that I want to.
Council, you are in your rebuttal time. I just wanted to let you know.
Yeah, so I've got my memory. I'm flashing back, but Mr. Finch said he wasn't going to follow Judge Hayes's order, which was actually started in December, even before the next order where he does withdraw. Judge Hayes, Hugh Hayes, required it by order then, and he said it was illegal or unconstitutional and a void order, so he wasn't going to. He testified this. He's not going to test it. He's not going to talk to Mr. Webb no matter what. And we believe, and I 100% believe, I'm not going to go into the other cases, but there's an issue of if you're going to review my fee, if I'm going to have to give this information through the special litigation committee expert that was hired, CPA, and I don't get to control the fee and do what I want to with regard to the fees, because he was not going to remain on those cases. Indeed, he already had Rebirth Plus with Mr. Brandon and that he was working for and representing. But to just sort of finish out real quickly is that I had no notice that we were going to talk about a fee agreement in terms of enforcement fees and so forth. It was never in there. It wasn't an issue. There was no argument about it. We didn't discuss it. And that's why the fee agreement, I was dealing with we were dealing with my motion to strike the issue of the voluntary withdrawal and the invalidity of the agreement, not any claims that the charging lien lawyers were actually making. In fact, it was.
Did you argue that there was some kind of due process violation in that regard?
Yes, I did. I found a rehearing. I said, I didn't know, and it should have been capped under Rosenberg 409 Southern Second, 1016. Florida Supreme Court, 1982, the year of my graduation from high school. I hope I've been clear, but my perception is, obviously, I feel like this was not fair, and the trial judge is a colleague of mine, even though he's a Florida fan. I'm a South Carolina fan. None of us are any good at this point. But he simply, the ruling isn't supported by common sense and real facts, because as a client, if you don't have any conversations with the lawyer, you communicate with the bar once, they say it's a civil matter, don't do anything for you. And your lawyer in the shareholder derivative action prepares an affidavit for you to sign related to putting money back in the company to be able to pay for the roofs that you've already agreed to repair. Those several things can't, in my view, as a matter of law, frankly, cannot support that the concept of what required by Pharaoh, that the client did something to create a conflict that now you can withdraw and still get paid in a case that.
Understood. Counsel, you're over your expired
I know.
time. Thank you.
Well, good morning to the panel. My name is Alex Finch and I represent the appellees in this case. I was also trial counsel and one of the charging attorneys in the underlying case. It's clear y'all have read the briefs. And first I'd like to open up any questions you might have to direct the time here to what is of interest to you. If,
Why would this sort of contingent agreement pass muster under the rules and then the Florida Supreme Court case law stating that contingency fee agreements that don't comply with these rules are void as a matter of public policy and unenforceable? Can you address that? Why does it comply with the rule? How do you get there?
well, it's not really the issue of the agreement. It's the issue of an added party to the agreement, Fromming and Finch. There's
Who under
no,
the rule was supposed to sign though, right? I mean, isn't the rule clear and express? Sorry. He was supposed to sign it under the rule, right?
he who.
Mr. Fromming.
Not necessarily, Your Honor. The rules say, my understanding rule, and Katz addresses this, is not every associate of a firm has to sign on to an agreement who provides services.
But it's a new firm, right? It's Fromming and Finch, the F and F firm.
Right, this would be a different question if it was an associate. I think everybody agrees with that.
Right, but the testimony for the court from the client, from Webb Roofing through Mr. Jordan, and through my testimony was that Fromming and Finch was formed as a staffing arm to meet their increased staffing needs because of a horrendous volume of cases, both from them and other clients.
Can a firm be of counsel to another firm?
Pardon me?
This sounds like a dumb question. Can a firm be of counsel to another firm?
Um,
You could see lawyers being of counsel to another firm, but that's not what happened here, right? An entirely new firm was formed.
no, more practically and appropriately, Finch Law Firm became a part of Fromming and Finch, brought the client and the contract to that firm.
But then that firm doesn't sign your agreement. I can't,
Because I'm interrupting you.
no, go ahead.
Because I remained, the testimony is crystal clear and unchallenged, that I remained the supervising attorney, the responsible attorney, and that all attorneys under Fromming and Finch and staff work under my direct supervision. It was me. I remained the client. The client felt I was their attorney, testified as their attorney, and Mr. Webb, the director that was in dispute with Mr. Jordan, felt I was the attorney at all times for the company. That's why when he brought a bar complaint, he didn't bring it against Fromming and Finch. He brought it against Alex Finch because
So then-
it was my client.
Did Fromming and Finch do the notice of charging lien where they filed it or no?
Yes, the charging letter filed
Yeah.
had the name of Fromming and Finch because I am Alex Finch is a member of Fromming and Finch.
But isn't that problematic under the rule? Like, we've got a firm name not as how I read the rule, and feel free to tell me if I'm wrong, because this is truly the crux of my questioning. But if then that firm doesn't sign the contingency fee agreement, and that firm is the one that did the notice of charging lien, and that's the firm that is trying to get these fees, I feel like there's the gap missing in the flow chart here.
I believe that, Fromming and Finch and Finch Law filed the charging.
Right,
Not just Fromming and Finch.
but both firms did, but then how does that get around the sentence in the rule that says no lawyer or firm may participate in the fee without the consent of the client in writing?
Right. I'm the lawyer. I'm the,
Right, I understand you, the lawyer, are straddling both firms, but what about the two firms? Only one
I
of
don't
the
understand the
firms,
question.
only one of the firms signed the agreement.
right,
Correct.
because it was no different than if Fromming, Finch Law Firm had done a name change. To change their name to Fromming and Finch.
Then
PA.
if it's that easy, then why do the two separate firms file the charging lien?
To provide a vehicle to pay staff and other attorneys to the income from those things, not to create a fiduciary responsibility separate and apart from mine with the client. And that's addressed in the brief in the Freights case and the Buckley Towers case, where an attorney who has a contract with a client moves on to another firm and goes into that firm, sorry, excuse me, Your Honor, the fiduciary responsibility and the duty of the client goes with it and maintains the ability to obtain the fees under that contract. And that's cited, sorry, in the brief, I think on page 441, 442. And the agreement can be modified. There's nothing out there. In the appellant's brief, it says, all cases agree you can't modify. Untrue. That's just not true. There's no case saying that written fee agreement, that's a contingency fee agreement, cannot be modified. It can be modified by agreement of the parties, oral agreement of the parties.
Is
Counsel,
there
if we-
some, oh, sorry. Michelle Della.
Okay.
If we disagree with you that it can be modified by oral agreement, let's say we agree with you that it can be modified, but we disagree that it can be done by oral agreement. We think it has to be done in writing, modification. What evidence would you point to show a written modification?
Okay, as a brief, as in the answer brief, sorry. Thank you, Your Honor. And as found by the trial judge, everything between the firm and the client, everything was electronic. Submission of claim. It wasn't an individual agreement per claim because it was impractical.
Everyone acted as if it'd been modified. I think
No,
that's-
they modified it because they sent it, the firm was formed at the express wish of the client to get more attorneys. Then they sent claim after claim after claim and communicated claim after claim after claim with Fromming and Finch as the one with, and then performed under the agreement, emails also, letters. and
Yeah,
checks.
I'm clear on that from the record.
So,
But do any of those emails or any of that practice, anything that was going on satisfy all of the requirements of the rule for contingency fee agreements? 4-1.5, I think it is, but.
yes, because the agreement operated under by agreement of the parties was the first agreement, and it was modified through emails and all of those things through assent by the client. When you look at the cases dealing with the UETA, and there are 4 cases within the 4th BCA, and y'all are not the 4th BCA, dealing with ratification, adoption of contingency fee agreements, sometimes signed by no one, sometimes signed by one person and not the other. Where you looked at the purpose of those emails is just assent. Does the
Sorry, are
client
those in the
know?
context of contingency fee agreements?
I'm sorry, say that again?
Are the cases you're addressing in the context of of contingency fee agreement?
All 4.
Okay,
It's Font versus Nelson versus Pathmark, Katz,
Cats is not, that cats can't be helpful, right?
well, it does in the fact that they address the issue of an email. Cats was a partnership agreement and a referral.
Yeah, but Katz is saying, right, that we're not operating under normal contractual principles here. We're operating under contracts that have to conform with the rules, right?
Right.
And so therefore, the agreement doesn't comply and is void, relying on.
Right, but they
Supreme
addressed
Court
the
authority.
email between the one firm and the other and said it wasn't clear enough to constitute an assent of the parties to that situation. That's where the problem fell in.
So
Katz.
can you pinpoint us to a place in the record where you have a document that sort of saves this case from being like Katz? Like, where is in the record an exact email that you think gets you there in compliance with Rule 4.1.5?
The transmission of all of the cases, the acceptance of and communications to enforce those claims. All of those are email transactions. All of them have to do with a transaction. Remember, the base agreement was a master agreement. There weren't new ones. It didn't become effective until you submitted the claim. That's when the contract occurred. And they submitted all those claims for services under that agreement to Fromming and to Fromming and Finch for services. They agreed to the payments to Fromming and Finch for the services and no separate payments to anyone else, any other law firm. So is there an email saying, hey, we got your new attorney and here it is, and we're going to go under the same agreement? The answer to that is no.
So now it sounds like you're in line with Katz.
No, because what the UETA says is you have to look at the totality of the circumstances, and that if an email submitting a transaction is not meant to be binding with the person whom you're submitting, then you can put in the email, we're not going under this agreement. This is subject to a later agreement to be signed. None of that happened because it was understood, it was agreed upon, and it was directed by the client to use that firm, have more attorneys available to do
Well,
all.
counsel, when you say it was directed by the client, can you point us to the evidence other than my understanding of the review of the record is the client said, we need you to get more lawyers. We need more lawyers working on this case. We have
The
more
test-
stuff coming in.
Okay, but, yeah.
Right, not please go hire another firm or please go create another firm.
The testimony from me at trial and from Brandon Jordan, the designated client contact, was we need you to get more lawyers.
Right, which is different from the mechanism. of
One,
how you do get-
and then, so I acceded to that request and told and this is all in the record. I told Mr. Jordan, I've got more attorneys, here they are, I formed a firm so that we can provide more attorneys for your cases. And that's what occurred. From that point on,
Right, and maybe
before that,
it's slicing hairs, but you requested to do something and you told him how you did it. He didn't direct you on how to do it, I guess is the point I'm making. Not here nor there.
well, I don't think a client could direct the attorney to form a firm or to do. So no, the attorney responded to the client's directive that it needed, or statement, complaint, whatever term you want to put there, that no more attorneys were needed, with the assumption being if you didn't get that done, then the business would go elsewhere. So when the client said, I need this to get my cases done appropriately, then the firm, I did what the attorney said. There's no question in the record at all, but that Web Roofing, through its designated contact, knew the terms of the agreement, knew the parties doing it, knew who the responsible attorney was, knew that the agreement controlled the financial arrangements between the attorneys, and there's just nothing there. And when you look at the cases, respectfully, they deal with assent, the client knowing. In the Pathmark case, for instance, Font Nelson case, there's emails going back and forth, and the client never eventually agreed with whatever the term was, right? And the problem they found there was not that there wasn't an attorney signature on it, but that there wasn't a client signature, because the client signature showed assent, understanding. No credible argument can be made to this court that Web Roofing, the client, did not ask for it, agree to it, assent to it, and perform on it. The evidence is overwhelming, partly because appellant declined to provide any evidence whatsoever at the hearing.
Do you agree, counsel, this may be a really simple question, but if we find that the agreement is unenforceable, your client, you were likewise not entitled to enforcement fees? If
Oh,
the-
you mean a attorney's fees for?
Yeah, they
yeah,
seem like
yeah.
they should be prevailing party fees, but they're not. So like enforcement fees, you sue to enforce this
Yeah.
agreement. You agree that if that agreement goes by the wayside, if we adopted opposing counsel's view of the case, that you're also not entitled to enforcement fees. Am I correct about
Right,
that?
the sole
There's-
ground for.
Yeah, is the
attorney's fees
contract.
and enforcement of the contract.
Okay, so can you address opposing counsel's point that then, my understanding is all that we are left with is quantum Merowit. And what I am wondering is about this 10% threshold, and if you can address his comment that exceeding that would be improper under Florida law.
Okay, so he cites Rosen versus Levin, or Rosenberg versus Levin. That dealt with a pure contingency fee contract. The contract in this case is what's commonly referred to as the mixed fee alternative contract.
Yeah, but we wouldn't be enforcing the contract, right? We would just be in wholesale quantum Merowit land
Oh.
because the contract, assuming his view of the case was correct, which I'm not saying, but let's just start there. If I don't have the contract, are they still, should we still be limited by the 10% cap set forth in the contract as he has argued, or no? And why not?
Well, no, because there would be no contractual cap.
But he has stated that Florida law lets him get there because it would be bad public policy to sort of reward people for creating a contingency fee contract that fails to comply with the rules.
Well, in our brief, there are Chandris, a case called Cali.
But Chandris, in
Right.
footnote 4 of Chandris, they say you can recover these quantum Merowit fees.
Right.
And so you're saying that's just wholesale, they're not cap? I mean, I don't think that it addresses the cap.
It doesn't. That would be, if y'all find that an interesting point, something to write on, because there's no case to address it. There's no.
What about the
there's no
Rosenbaum case?
Addressing, if it was enforceable in a mixed fee, because there are multiple cases say that a mixed fee contract is not capped by the contingency unless it specifically says so. This one does. But there's no case saying, well, what happens when you involuntarily get out and your quantum merit, does the cap apply or not apply?
So you're saying
apply.
Rosenbaum doesn't address that situation?
No, it doesn't, at all. But neither do the cases that lift the cap in a mixed, it's new ground to be plowed for the panel if it so chooses. But in the absence of the agreement, there are 4 Chandris, Hernandez, all cases cited, and all say, go back and figure out quantum merit under the totality of the circumstances. Because we've ruled you don't have an agreement. So if there's no agreement, there's still quantum merit. So that's to address counsel's argument of, well, if you gave this knowingly bad agreement, you're not gonna get rewarded through fees. You don't get any, that's just not the standard. And any of the cases, the other one's O'Malley, that's cited in the O'Malley versus Freeman. So with an agreement, without an agreement, we're entitled to fees. Without an agreement, then the voluntary, involuntary issue becomes a non-issue. Because that only applies when you have a valid agreement. And I'd like to address, unless the board has other questions on this particular issue. The voluntary, involuntary, the whole point appellant makes is you got to work it out with your client. When you're having a problem with your client, you got to work it out. You can't just say, I have to withdraw. This is, in their brief, they address 4 separate times where the client, through Mr. Webb, accused the charging attorneys of intentional torts intentionally harming the client, malpractice. And they address the email from Mr. St. John acknowledging a conflict. It wasn't just Mr. Pete, we don't like how you're talking to us. We think you're rude. None of that. You are hurting my company. You are engaged in fraud with another director. Those are far beyond a broken down client relationship. That's an adverse relationship that under the Florida bar rules that are cited within the brief mandated withdrawal. Court recognized that. Secondly, even if it wasn't mandated because of that kind of conduct, couldn't work with them. You're being accused of things, threatened things. That's permissive withdrawal for good cause on the other rule. Either way, if you find that there's a valid agreement, then there is an involuntary termination. And the facts to determine that were before the court and it ruled, and respectively, you're bound by those credibility. He found the witnesses to be credible and the information to be credible. And that's what comes before this court. And lastly, the due process notice issue. They claim that we shouldn't have to pay enforcement fees if the court finds the agreement to be enforceable by forming a bench, because I didn't know about it. Untrue. And the response to the motion to strike that's raised as an issue, and the motion to quantify, it's raised as an issue. That enforcement people aren't. They chose not to respond. They chose not to present it.
Was the motion to quantify set for hearing before the court
Yes.
on that day?
Yes,
Okay.
all the motions relating to lien would be heard that day and resolved.
Did they argue specifically due process in the initial brief? Do you recall that? I understand it's below, but was a due process argument made before us? Do you recall?
Not
Just
that not that I saw, Your Honor. There were 6 issues raised, validity of agreement.
Yeah, that's okay, counsel. I appreciate it. I think we're looking at the same.
Yeah, no, there's no issue raised or set briefing on the due process issue. And based on the rules of this court and other courts, they waived that, we failed with this court.
Thank you, counsel. Thank you both
Thank
for your
you.
time today and your briefing before this court. We are adjourned.
Have a nice day, y'all.
You too.